Hey everybody, this is an oddball case that I happen to come across all the time because it deals with conditions of probation and amended sentencing, and I think it's kind of funny, and hopefully you do too. So this is Edmond versus State. You'll see it's from 1971, just turned 54 years old, but despite its age, it's still cited fairly regularly. So let's get right into it. Conditions of probation imposed by a court must be reasonably related to the probationer's rehabilitation to a law-abiding life and not unduly restrictive of his liberty or personal self-expression. A condition requiring a short haircut does not meet this test. Remember, this is the 70s we're talking about here. Defendant appeals from the judgment of conviction and sentence for the offense of possessing marijuana. We get a long-haired, pot-smoking hippie on our hands here. Defendant and a friend were stopped in their automobile by a policeman for some things never change, for reasons unknown. The officer searched the car and found a pipe, which was later determined to have marijuana scrapings in it. The young men were arrested and subsequently indicted for possession. Defendant claims he made a plea bargain with the district attorney, who denies any such thing. Whatever the truth, defendant did enter a no-low plea. After summary hearing, the judge, noting that this was a first offense, orally sentenced him to 2 years on probation, subject to the payment of a $500 fine, and more importantly, to his obtaining and maintaining a short haircut during the entire period of probation for the full 2 years. Critically important. Defendant immediately met the probation officer, paid the fine, was read the rules of probation and signed them, along with a waiver of extradition in case he left the jurisdiction. He then asked the lawyer to request the court to delete the haircut condition. 2 days later, his lawyer presented the judge with a petition for modification of the sentence concerning the haircut, with a prayer for, I don't know how to say this, rule nisi is the way I've heard it said, to hear the matter. The judge declined to sign the rule and instead directed counsel to bring defendant back 2 days later for resentencing. For obvious reasons, the petition was not filed or served on the district attorney. However, the record shows that the state made an appearance at the resentencing, such as it was. At the outset of this proceeding, the judge stated that he had not yet signed any judgment in the case, that following the non-binding oral sentence, he had made subsequent investigation, and that he had determined that the sentence should be modified. The judge is unhappy. Defendant's lawyer first argued several legal issues, and finally made a motion to change defendant's plea. He met adverse rulings throughout. The court then informed defendant that it was going to reduce his sentence, that he would get instead 1 year in the penitentiary and a rebate of his fine, which had been prematurely paid. So it's down from 2 years of probation to just 1 year in prison. So it's a lighter sentence, obviously. The court signed this judgment on the spot, and defendant went straight to jail. The state contends that the oral declarations of a judge are not binding. That as no judgment ordering probation was ever signed, the defendant never commenced serving such a sentence. That the matter of sentence was still within the breast of the court, and therefore the written judgment and sentence of 1 year's incarceration must be affirmed. This was saying that there was never a written sentence, so he never started serving the sentence, and therefore the 1 year incarceration is the initial sentence and the binding sentence, and that our hippie needs to go to prison for a year. While it is true that an oral sentence is not a binding judgment of the court, the law is also clear that once a person has entered upon the execution of his sentence, begun serving a sentence, the court is without power to change it by increasing the punishment. This is considered double jeopardy. Once you begin serving, it cannot be increased, essentially. I like this line. We do not believe the question of whether defendant's punishment was increased merits discussion. Remember, the trial court said, I'm going to reduce your sentence from 2 years of probation to 1 year in prison. And intentionally or not, that could have been a way to try to get around double jeopardy, because again, the issue is whether you increase punishment. One is less than 2, but I think substantively a year in prison. Everyone would agree that a year in prison is more punitive than 2 years of probation. States argued the point. The real issue is whether the defendant had begun serving a sentence. So because we know that these punishments increased, if he had begun serving a sentence, it's double jeopardy, and you need to vacate the sentence. To take the technical view that nothing had happened yet because the judge had not signed a document is to ignore the realities of court practice and administration. Every lawyer knows that judges do not sit at the bench drawing complex orders or judgments. In a civil action, the prudent attorney comes armed with suitable writings to present if he prevails. It's usually come with a judgment that would give you what you want, assuming that you win. And so if you win, you present the proposed order. Assuming the other side doesn't have any objection, they'll just sign that, and that becomes the judgment in the case. In a criminal action, the state has forms which only require the insertion of the date, name, charge, and number of years. The transcript here reveals that in this type of case, the formal judgment of conviction, sentence, and probation is prepared by the probation office and submitted to the judge at some later time for signature. Without knowing what backlog of paperwork this particular office has, we can assuredly say that it does not have the power to delay the running of a sentence because of clerical problems, when all other necessary steps in the process have been completed. Defendant had gone with a probation officer at the court's direction immediately following the oral sentence. He was instructed in the rules of probation and signed all the required papers. He paid his fine. He was released because he was a probationer, expecting and expected to follow the rules. He did not break the haircut condition. That'd be impressive if he had, really. You have to grow that hair pretty fast. In any case, he did not break the haircut condition. He pursued a legal process to have it changed. If the probation office had neglected to draft a judgment for 2 years, then by any standard of due process, defendant would have been entitled to discharge. Accordingly, the court was without power to resentence him, and the subsequent judgment and sentence is utterly void. This standard is actually, usually don't cite to this case, but this is something you will see frequently. I mean, it's not a common issue, so I shouldn't say frequently, but anytime you have a question about whether a sentence has begun running, that's a common one. Going with the probation officer, signing any kind of probation paperwork, and that often happens the day of sentencing or the following day. So you'll see that specifically referenced even today pretty regularly. Okay, there remains the sentence of 2 years probation with a short haircut. So now we're back to the original sentence rather than the amended sentence of 1 year in prison. So back to the 2-year probation. There remains the sentence of 2 years probation with a short haircut. Defendant vigorously attacks the condition as a violation of the First, 8th, and 14th Amendments at the very least. I don't know about the 8th, but the other two, sure. We not only agree, but take judicial notice that the rotunda of the State Judicial Building contains busts of 3 of our most eminent and hirsute justices, featuring the magnificent shoulder-length locks of our beloved Chief Justice Joseph Henry Lumpkin. As Judge Wyzanski of the District Court of Massachusetts said so well, today, many of both the younger and older generations have avoided the increased cost of barbering by allowing their locks or burnsides to grow to greater lengths than when a haircut cost $0.25. Whether hairstyles be regarded as evidence of conformity or of individuality, they are one of the most visible examples of personality. This is what every woman has always known, and so have many men, without the aid of an anthropologist, behavioral scientist, psychiatrist, or a practitioner of any of the fine or black arts. I'll look up what year that is at some point, but that's magnificent. We recognize that a person occupies a special status while on probation, during which time his private life and behavior may be regulated by the state to an extent that would be completely untenable under ordinary circumstances. The rationale for this power is basically, of course, that the person has been convicted of a crime and would be serving a sentence but for the grace of the court. He's a prima facie risk to society. It will, however, allow him the opportunity to prove himself otherwise. Nonetheless, once having shown weakness, he may not place himself in a position to be easily tempted again. Such condition of probation as avoiding undesirable people, abstaining from alcohol or drugs, and even holding a steady job fall into the no temptation category. Others, such as violating no penal laws, are self-evident. Requirements for reporting to a probation officer and remaining in the jurisdiction are basically devices for checking on the efficacy of the probation. So basically, it's ordinary to have conditions that will turn you into a law-abiding person. The conditions listed so far would probably be endorsed by a significant segment of society as reasonable controls on risk, i.e. they are believed to directly affect the probationer's tendency to either further antisocial behavior or rehabilitation. While such terms as undesirable people and general good behavior border on the fuzzy and would be open to differing interpretations, they still pertain to social behavior in which society acting through its courts has a legitimate interest. I still see this one sometimes. I don't think it's phrased exactly that way, but it's something along those lines. And I've always wondered if there are any cases where a violation of that has been litigated. I'm sure there are. I haven't really looked at it in depth. Unfortunately, we have no enunciated standards in case law for testing conditions of probation. The closest we have come is the statement, service of a sentence on probation is conferred as a privilege and cannot be demanded as a matter of right. On the other hand, this does not mean that a defendant's liberty is something that can be the subject matter of whim or fancy of the trial judge, meaning the judge has a lot of discretion, but they can't abuse it. However, the American Bar Association has published a tentative draft of standards relating to probation. That draft reads, conditions imposed by the court should be designed to assist the probationer in leading a law-abiding life. They should be reasonably related to his rehabilitation and not unduly restrictive of his liberty or incompatible with his freedom of religion. The drafter's commentary observes that this means conditions must achieve a balance between oppression and necessity, between interference and utility. The condition at issue here represents no more than a particular judge's taste in personal appearance and one which has no demonstrable effect on behavior. Society has not authorized its courts to make such conditions for probationers. Some other judge could well decide that they ought to wear striped uniforms and have shaven heads. Limited as their freedom undoubtedly is, probationers are still individuals, not inmates. Having been deemed worthy to stay in society, they must either have the right of a free man to a personal self-expression which does not infringe on the rights of others, or the whole concept of rehabilitation through probation goes down the drain. Outside becomes prison. While few young men would choose to serve a sentence rather than cut their hair, even fewer would finish with a sense of respect for criminal justice. A condition of probation which invades a person's constitutionally protected right to personal self-expression, and which is not related directly to his rehabilitation, cannot meet the test of reasonableness. We therefore reverse the judgment and remand to the trial court with direction that it enter as its judgment nunc pro tunc the original sentence of 2 years to be served on probation, subject to the payment of a $500 fine, but with the condition of a haircut deleted. I wonder if he grew his hair out after that. That'd be funny if he didn't even bother, just to prove a point.